She states, "Don't worry, I'll make sure Lyra doesn't remember you, and I'll make sure she remembers a real man as her father," clearly indicating that she has no desire to foster a positive relationship between the minor child and Mr. Templeman.
Court will note the appearance of Ms. Thomas on behalf of plaintiff, Mr. Moss on behalf of defendant. This matter is before the court on the plaintiff's motion for order of temporary custody support parenting time. Ms. Thomas, just to clarify, in paragraph 7 of your motion, you state that the plaintiff was arrested for domestic violence. Did you mean the defendant?
I did. I'm sorry.
Okay. I just wanted to clarify. I thought that was inconsistent with the other, and I want to make sure.
It would have been. Yes.
Okay.
I'm sorry.
Okay, go ahead, Ms. Thomas.
Thank you, Your Honor. Your Honor, as the court, I'm sure, has read both the motion and the answer, the parties have one minor child, Lyra. She's age 4. The parties have a very tumultuous relationship. They separated on or about February 8th, 2024, and that was after a domestic assault in which defendant was charged with domestic violence. The plaintiff was fearful for her safety and the safety of the minor child, so she moved with the minor child from Lansing to Battle Creek, where she and the minor child presently reside with the plaintiff's parents. After the defendant was charged with domestic violence and a no contact order was entered, the minor child's grandfathers actually worked together to ensure that defendant and his family did have continuing contact with the minor child in the home of defendant's parents. However, the transportation was left totally to the plaintiff's family to get her to Lansing, to retrieve her from Lansing, etc. Ultimately, the charges were dropped as plaintiff chose not to pursue the matter, hoping to work out with defendant the ability to co-parent Lyra. Unfortunately, that does not appear to be the case. Defendant is still apparently continuing with anger issues, and the parties are barely civil to one another, let alone able to work together for the best interests of their daughter. Historically, in their relationship, the defendant has bullied plaintiff into submission and ridicules rather her about her lack of intelligence. The defendant's increased use of alcohol over the past few months have escalated the situation, and the unrest between the parties was continuing to grow to the level that it hit in February when, in fact, the defendant was arrested. Although defendant appears to allege he has no more than 3 12-ounce Budweisers on the day that he was arrested for domestic violence, plaintiff certainly appears differently and indicates as well that Mr. Templeman drinks a lot of alcohol and not just beer. He drinks significant amounts of hard liquor as well, including in the presence of the minor child. Although defendant's answer denies multiple domestic violence incidents and perhaps prefers to have them referred to as altercations, he acknowledges law enforcement was called repeatedly to the party's home, obviously showing that there is unrest between these parties. Defendant would have this court believe that plaintiff was eager to have communication with defendant after the no contact order was lifted. However, any desire she had to have contact was solely to make sure that if Lyra were to be in his sole care, that she would be safe and that he was not continuing to drink with Lyra present. Obviously, his parents have been involved in the parenting visits during the period of the separation and while the no contact order was in place, and she was a little concerned that well, she was very concerned actually, that would Lyra be safe in his care if his parents weren't part of that parenting time. As to the best interest factors, plaintiff does confirm her statements as set forth in her motion. She further states that for most of Lyra's life, she has been a stay-at-home mom, and although defendant now alleges he has concerns about the care and safety of the minor child in plaintiff's care, and specifically alleges mental health issues, he has never had a problem leaving the minor child in plaintiff's care when he went to work every day. Yet now he questions her ability to care for the minor child and is requesting supervised parenting time, but also admits plaintiff is well able to give and provide the minor child with love, affection, and guidance and other emotional ties existing between the minor child and her parents. Yet also states she is not morally, mentally, and physically fit to provide for the proper care of the minor child, which is it. Defendant is showing his words and his actions do not match, and for that matter, even his words and his words do not match. With daycare expenses compared to the minimal pay positions plaintiff has been able to obtain, it was much more practical for the most part for plaintiff to stay at home, and she was in fact a stay-at-home mom for the majority of the parties' time that they lived together, which was shortly after Lyra's birth. When that was a situation, though, defendant had expectations, though, that plaintiff was the maid rather than a partner and a co-parent in the relationship. It was telling to the plaintiff that Mr. Templeman believes that irresponsible consumption of alcohol has no bearing on a party's moral fitness as a parent, which is what is stated in the defendant's answer. Certainly choosing to drink to excess in the presence of a minor child is not distinctive of high moral character. Plaintiff presently maintains her employment with Firekeepers Casino Hotel. She's able to provide for Lyra with a safe and stable environment in the home of her parents until she's able to save enough money and or defendant begins regularly contributing toward Lyra's financial needs pursuant to the Michigan Child Support Formula. It will take her a while to get reestablished and resituated, but her parents have plenty of room in the home and have welcomed her and Lyra into their home, in which they have been in for a long time. It's a environment that Lyra is certainly familiar with. She's been there many, many times. She was regularly stayed there when the parties were residing together. So any concern that Mr. Templeman may have made regarding her safety or care in that home is disingenuous for certain. It has been typical for Mr. Templeman to not allow plaintiff to have a voice. If she disagrees with his decisions, he simply does it his way, and plaintiff does not believe the parties, unfortunately, are able to make joint decisions right now, as defendant has historically bullied the plaintiff if she didn't comply with his wishes, and she's just fearful that continuing to do so regarding Lyra-related decisions. She just does not believe at this moment. She's hoping that it will change, but at this moment, on a temporary basis, she does not believe the parties can make joint decisions together. Therefore, plaintiff is requesting at this point a continuation of the longtime status quo wherein she was the primary caretaker as a primarily stay-at-home mom with Lyra, and grant her primary physical custody with reasonable parenting time with defendant, so long as there are controls on his ability to drink during or for periods prior to his parenting time. She is also asking for temporary sole legal custody of Lyra until such time as the parties are able. Hopefully, with the aid of counsel, we can work out a plan for Lyra's best interest involving how joint decisions can be made as far as legal custody. But at this point in time, it just doesn't seem possible. Also, we would ask the court to order that both parties exchange their income information so child support may be set pursuant to the Michigan Child Support Formula. And we would specifically note that we don't believe that there's any reason to send that to front of the court. That is just a significantly long delay at this point in time based upon their workload, and that doesn't seem necessary when there's two attorneys on the case and the parties can simply exchange information and determine what child support should be pursuant to the formula. Thank you.
Thank you. Mr. Moss?
Thank you, Your Honor. May it please the court. Regarding our response, I apologize. I was recently retained, Your Honor, and got the response to the court Friday afternoon. So I'm not sure if Your Honor has had an opportunity to review that yet. And this morning, I submitted a revised version, which is identical, except I realized the filing on Friday did not have my exhibits attached that are referenced within.
I noted that you referenced the exhibits and I couldn't find them. So.
Okay. Yes, thank you, Your Honor. So I guess regarding the allegations of the domestic violence, as counsel informed the court, plaintiff did not appear at the last court hearing in that criminal matter. Those charges were subsequently dismissed. More importantly, in my exhibit A is a text message that Ms. Young sent to a family friend, in which she indicates that there was no that Ryan didn't do anything to her. And she goes on to reference that the photo that the police had of her neck and were using as evidence, but it was a photo of her skin condition. If he had laid a hand on me, there would be a bruise the next morning, which there wasn't. So I think in regards to words not matching words, I think Miss Young's words are not matching her words in regards to those specific allegations. Further, while the no contact order was in place, there was no violation of that order made by Mr. Templeman. Additionally, during the entire pendence of the criminal charge, the parties continued to exchange the minor child. Mr. Templeman would exercise parenting time on a weekly basis from Wednesday through Saturday. He would occasionally spend time at his parents' house, as he comes from a close-knit family, but his parenting time was not supervised by his parents. Regarding plaintiff's claim that she was the sole care provider, the parties lived together for over 2.5 years, approximately 2.5 years since the birth of the minor child. During that period of time, both parties equally partook in their care and raising of the minor child. While it's true that Mr. Templeman did work outside of the home, when he was at home, he would partake in feeding, nap time, putting the child to bed, changing diapers, all of the normal duties that come along with being a parent. Regarding plaintiff's request for sole legal custody, while she indicates that the parties are unable to effectively communicate right now, there's been no indication or examples given of any important decisions regarding any of the matters related to joint legal custody where the parties have been unable to reach a consensus. Therefore, we think that that request is unfounded. Additionally, regarding the allegations of Mr. Templeman's use of alcohol, Mr. Templeman is obviously over the age of 21. He acknowledges that he would occasionally after work have some beers. There has been no indication, and Mr. Templeman vehemently denies any irresponsible use of alcohol, such as drinking and driving. With reference to the moral fitness of the parties, the statement that I made was that Mr. Templeman feels that the responsible use of alcohol has no bearing on his moral fitness as a parent. Regarding the safety of the minor child while in the care of, let me back up. While the parties were together, Ms. Young, while she indicates that Mr. Templeman did not have his concerns previously, the same could be said of Ms. Young. There's no indication that there was ever any issue of Mr. Templeman's parenting time or his ability to parent the minor child while the parties were together. It's only since she's moved out of the home these concerns have surfaced. The best interest factors, ultimately the friend of the court is going to make a determination of those, but I think most significantly for the court is my attached exhibit B, in which we reference the parties' ability to foster a positive relationship with the child and the other parent. Ms. Young recently, as of April 25th specifically, sent Mr. Templeman a text message in which she states, "Don't worry, I'll make sure Lyra doesn't remember you, and I'll make sure she remembers a real man as her father," clearly indicating that she has no desire to foster a positive relationship between the minor child and Mr. Templeman. Your Honor, for all of those reasons, it is our request that this court deny Ms. Young's motion. We would ask that the court consider granting Mr. Templeman primary physical custody and joint legal custody. In the alternative, we'd ask that the court order the status quo continue, that being Mr. Templeman having parenting time on a weekly basis from Wednesday through Saturday until a friend of the court can hear the matter.
Okay, thank you. Well, in this case, the court's heard the testimony as well as reading the pleadings. It does appear that the plaintiff was a stay-at-home mom for majority of the time that the child has been alive, and the child has been with the solely with the plaintiff since the separation back on February 8, 2024. So the court is going to maintain the status quo. The court is going to grant custody, temporary custody to the plaintiff. Support will be pursuant to the guidelines. The parties will exchange income information within 7 days of today's date. The court will grant to the defendant standard parenting time, alternating weekends, midweek, alternating holidays. And the court will order that during the time that the child is in the defendant's care, that he would not consume any alcohol. And that the court would order that the parties would participate and communicate through our family wizard in this particular case. With that, I'll ask Ms. Thomas that you would prepare the order, and I was gonna say submitted it under 7 day, but it depends on if you get the income information in that time.
Okay, so if we're going to exchange the income information within 7 days, can I have 7 days beyond that to submit it under the normal 7 day? Is that acceptable to the court?
I'll allow you to do that 7 days from next week, so that we can again, we don't have to schedule another hearing in this matter.
Okay, perfect. Thank you so much, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Thank you.